covering the news of a withdrawal at the sentencing period. Defense attorneys for convicted eye drop killer Jessy Kurczewski, want out. She was found guilty of killing friend Lynn Hernan and stealing from her. And so they said there's been this issue come up in which our client is basically blaming us for creating this story about what did or didn't happen in really the crime itself. Let's take a listen now to what the defendant herself, Jessy Kurczewski, had to say about this.
I did. I do not, because up until yesterday, neither one has done anything for me now because they had halted all proceedings due to the DA conversation they have had. So at this point, as much as I wanted to get out of Waukesha County and proceed forward and go through appeals, I don't, because nothing has been done for sentencing except last minute yesterday. Partial. I have letters of character in limbo. I have nothing completed for sentencing, so no, I don't. And I frankly blame the state for that. They proceeded to release this information, which should have not been done, and it has created this mess. So while they are requesting they should not withdraw on their behalf, I don't think this is right. Everything has been done wrong since they have came forward last week with this information. And I do say, no, I did not write it. There's cameras all over this jail. There's recorded phone calls. There's a lot of issues here that, no, everything should be stopped. And I need to look at my legal rights because I don't know what they are at this point.
I can tell you.
No, I do not think because of everything that I have since learned, no, I should not have either attorney, which is very hard, proceed at this point, and sentencing should be stopped.
So there is Ms. Kurczewski. Catherine, what do you think about her demeanor and her response to the court?
She seemed very determined and almost ready as to what her argument will be in front of the judge, thinking about the trial and the different theories as to how her friend died. She had several theories to fit the facts that was being given to her during the investigation. So she comes across as a smart person who can figure this out. And so it seems like that's what's happening here as well in her sentencing, that she might have figured out, hey, this is a way for me to delay it. But what I found interesting is she is claiming that she did not write that handwritten letter. So again, that puts her own attorney in a very precarious situation because they will have to be witnesses as well, whether or not they saw her or not see her write that letter.
Yeah, so Bob, you have a theory about the actual writing of the letter, don't you?
Yeah, my theory is that if you watch any of the trial, she was writing almost the entire time, like diligently writing. And I believe that all of these, it's a very long letter, but everything was written on the back of pre-printed court documents, which typically in most courtrooms, like you'll have a pile of pre-printed court documents, court orders, other various forms that they have. And so I think what she was possibly doing was taking the back, because you can see they're not lined. It's not lined paper. So I think what she was doing is at trial, she was sitting there and under the premise that she was taking notes, which is not unusual for a defendant to take notes during their trial if they're engaged in their own defense. So, yeah, that's my theory. I obviously can't prove it because I can't get my hands on those documents, but that's my theory.
Yeah, I mean, those lines were very well, they're very linear. I'd be all over the page just once I got started, but very disciplined. And of course, she's talking about her appellate rights. She's smart enough to know that the clock doesn't even tick and you don't have the right to appeal until sentence has been pronounced. And so while this thing lingers, she can't even file an appeal. Okay, so what's the judge think about this whole thing? Let's go back into court.
I consider all of that. I think I am left with the inescapable and unenviable decision here today to make a finding that at a minimum there's a serious potential conflict of interest, perhaps even an actual conflict of interest. Looking at the authority in State versus Miller, this court must presume prejudice to Ms. Kurczewski in requiring her attorneys to represent her going further. She does not have an objection. I think there's an additional basis that there has now been a serious breakdown of communication and a difference of objectives between Ms. Kurczewski and her counsel, that this is a relationship that cannot be mended. And even though it means that this sentencing hearing must be adjourned and that new counsel be provided for Ms. Kurczewski, I am going to grant with reluctance, but I think it's the right thing to do, the motions to withdraw by attorneys Kukler and Gallagher.
And what you hear is a collective, whoosh, I'm out of this mess by the attorneys. Conflict of interest is the overall reason for the decision, but the understatement of the day is a breakdown in communications between the attorneys and the client. Bob, I mean, the right decision, I'm guessing you're going along with that?
No question. From both sides, from obviously the attorney, but as well as the defendant. You know, I mean, she clearly understands that there has just been that schism that is irreparable in terms of that relationship, and that they clearly have different, objectives completely. You know, at this point, the attorneys, would have no choice but to kind of hunker down and be in defense mode as they now understand that their client has turned against them and thrown them under the bus, in which case they're not going to be able to effectively represent her at sentencing. And her argument is that, look, these lawyers weren't doing anything in terms of trying to mitigate at the sentencing hearing. They weren't doing the work. So for that reason alone, I don't want, it's not fair for me to go through the sentencing. So I think for both sides, the only move is to obviously she's in custody. We all want the sentencing to happen. It's not like she's walking around free, during the pendency of this. So
right, it's a formality. And she points out one of the key issues is that, if there's going to be an appeal, and I'm sure there will be, you can't do that until the sentence is pronounced. So, Catherine, as weird as that letter is, do you think there would be or should be some investigation into the underlying facts or allegations?
Definitely. When you receive something as detailed and as salacious as that it's so outrageous, no one could have made that up, you need to investigate it. Lawyers need to abide by the ethical duties, and the defendant, whatever her involvement was in any of that, if any, all of that need to be investigated to ensure that the proper people should be made accountable for whatever collusion that happened there, so that our court system will remain intact with integrity. So I hope there is an investigation, thorough investigation going on regarding this.
Okay, so we have sentencing still to come in the Jessy Kurczewski case, and we will keep posted on that. We're going to take a break. Another trial we're covering, this one out of Atlanta. You might be getting your, you need your fix of Young Thug. Last Friday they were off, but they're back at it today, a delayed start. We'll catch up on that case as well as other items. Stay where you are. This is Law and Crime.